You're listening to The Mark Cox Show. Find everything Mark Cox at 971talk.com/Cox.
I don't know which way the Supreme Court's going to go, and I don't know which court he had in mind. But this is an intellectually dishonest piece of work that the Ninth Circuit has produced tonight, because it essentially consists of substituting the judgment of 3 judges for the President of the United States when the Constitution unambiguously gives this area of jurisdiction, foreign policy, exclusively to the president.
Well, there's Judge Napolitano, who I'd have to give a lot of credit to because he agrees with me. I'm just teasing. He's a judge. He understands the law, and I thought it was interesting that how he perceives this ruling by the Ninth Circuit Court of Appeals. My apologies for that. When you say that just so often, it kind of rolls off your tongue, so you have to kind of be careful with that. I apologize. We're joined now by John Malcolm, who's a legal analyst with the Heritage Foundation. John, how are you?
I'm doing fine. Thanks for having me on.
Well, thanks for giving us some time today. Everyone told me not to be surprised by a ruling like this out of the Ninth Circuit necessarily, but in terms of the content of the ruling, what is your take on what they issued yesterday?
Well, I think the court stretched in order to reach this result in a number of ways. So the first is that they granted the state of Washington and Minnesota standing to assert this claim, essentially saying, well, there's no question that state universities, some of the students and some of the teachers are affected, and of course you have an interest in the smooth running of state universities, and that's good enough to give you standing. I think that's shaky. And then what the court did was he said, well, look, we recognize that the statute gives the president authority to do this, but of course it has to be implemented in a constitutional manner. And they found 2 constitutional questions that I think were a stretch. So they said, one, there may be due process concerns, lack of notice and opportunity to be heard for some of the people covered by the order. Now, the order was broadly written and would, according to its terms, cover people with green cards. The White House counsel's office has come out and said, let's be clear, we're not talking about people with green cards. The order isn't going to apply to them. It's also not going to apply to people who are in the country illegally and we want to remove them. This is for people who have not yet entered our shores, and it's a matter of sovereignty that we can keep them out if we want to. And the court said, well, the White House counsel may say that, but that's not what the order says, and therefore we think there may be due process concerns. The other problem that the court pointed out was to say, well, this may really be a Muslim ban, and then it would violate the Establishment Clause, which prevents discriminating against religions, and the Equal Protection Clause. Now, I don't see this at all as a Muslim ban. I mean, first of all, the executive order is neutral on its face with respect to religions. There are 50 majority Muslim countries around the world. This only impacts 7. The court said, well, there's no evidence that there have been any terrorist attacks from people who came from these countries. Well, first of all, there have been 71 people, probably more than that, but at the end of 2014, 71 people from those countries have already been convicted of terrorism-related offenses. But even if there weren't, these were countries that were identified by both Congress and the Obama administration as posing a heightened risk of terrorism because they are either state sponsors of terrorism, safe havens for terrorists, or they either lack the capacity or don't cooperate with us so that we have no confidence in their vetting process. So I actually think that the president on the law is on fairly solid grounds, but, you know, the Ninth Circuit is the Ninth Circuit, and the Supreme Court is fairly evenly divided. So, you know, we'll have to see what's going to happen now.
Yeah, to make sure that my listeners are clear on this, because it is rather confusing.
Sure.
The judgment yesterday was not on specifically the executive order, but whether or not to continue the temporary restraining order issued by Judge Robart, correct?
Yes. So the judge entered what's known as a temporary restraining order, which is a really preliminary phase. It's just, can we put this thing, implement this thing pending a hearing and, you know, more factual development. And once he granted that TRO, then it becomes a little bit of an uphill slog to get the TRO overturned.
Okay.
And the court sort of hides behind it, says, well, this is a fuzzy record, and therefore we don't think we have enough to overturn this. It's a little bit hard at this preliminary stage to do it. Now, the Trump administration's got a couple of options. They can either continue to appeal, seek an emergency stay by the Supreme Court. They can go back to Judge Robart and request an expedited hearing on the matter. Or frankly, one thing that they might consider doing is ripping up this executive order and entering a new one that lays out a better factual basis and also addresses a couple of the concerns the Ninth Circuit raised, like whether or not it applies to green card holders and the like. I'm not sure which of those options you're going to take, but they're all on the table.
Yeah, I wondered. And so the next one of those steps that you mentioned would mean then going back and actually arguing this in front of Judge Robart for a final decision?
Yeah, so again, it's just a temporary restraining order. The next step would be to have a factual hearing, and you decide whether or not to enter a preliminary injunction, and assuming he did, and I assume he would, you'd then have a trial on the merits for an ultimate decision about whether that injunction should become a permanent injunction or should be lifted. That could take a while, but of course it could also be handled on an expedited basis because of the national security implications. Sure.
We're talking to John Malcolm from the Heritage Foundation. John, on the issue of whether or not this is that they've somehow abridged the Constitution, especially the Establishment Clause. I've heard it said several times, and I guess I've parroted that myself, that for someone who wants to immigrate here from Syria or one of these 7 countries, are they covered by our Constitution? I mean, is it possible for us to violate a constitutional right of someone who's a non-citizen?
The answer is basically no. So if you have a green card, you've got rights. If you are actually in our country, even if you are here illegally, you have limited due process rights. You can't be deported without a hearing and an opportunity to be heard.
Okay.
But generally, and the Supreme Court's been clear on this, if you are an alien who has not yet entered our shores, you have no due process rights. Now, what the argument would be is, well, yes, but a government can't take arbitrary action that is on its face discriminatory.
Right.
So if the government were to say, we are not going to let in any alien who just happens to be a Muslim, you might be able to challenge that, and that is the argument that the court is saying, well, we need to have more factual development on this. The states are claiming that this is a de facto Muslim ban, and we're at least going to let them make that argument.
Yeah, I hate to. I don't want to push you into hypotheticals here. I mean, if the Trump people scrapped this one and came back and said, you know what, we're just going to halt all immigration period for 6 months. We'll see you. We'll see you in 120 days. I mean, if they just said we'll see you in 180 days, they then couldn't accuse him of targeting it at one group. So I'm guessing if we saw another executive order, it would be reworded somehow or cover a broader number of people. That can't be what these liberals want.
No, and they could, of course, go in a different direction, which is sit there and say, look, we're going to target the same 7 countries, but here is the factual layout for why it makes sense to cover these 7 countries. And by the way, we are going to make clear that this executive order does not apply to green card holders. It does not apply to people who are already here, even if they're here illegally, but it does apply to people from these countries who have not been admitted to these shores. Here are the reasons why. And, oh, by the way, we can make case-by-case waivers, which the current executive agreement already allows for.
Right. Yeah, that's a great point. Well, I appreciate you clearing up some of that because it does get murky for those of us outside of the legal spectrum. I can say that.
That's murky stuff.
John Malcolm with the Heritage Foundation, I appreciate your time.
Good to be with you.
Thank you very much. John is the director of the Edwin Meese Center for Legal and Judicial Studies at the Heritage Foundation and knows of which he speaks. So that's why I wanted to get his take on that. I mean, seriously, they're afraid that that he somehow violated the rights of Muslims. What would they say if he just said, I'm stopping all immigration for 6 months. Check back in with me when it's over. Could you imagine the meltdown by the left? Who would they blame then? Oh, he must hate Christians. He must hate the English. He must hate the Europeans. He hates everybody, which is what they seem to think anyway. These people are whacked out. Can I just tell you that? That's what it gets down to. I'll get to some of your phone calls coming up here in just a couple of minutes. 314